All rise. The Court of Appeals Division 1 is now in session.
Good afternoon. Thank you. Please be seated. This is the time set for oral argument on our case captioned State of Arizona versus the Honorable Judges Rogers and Ditsworth, Calvin Morgan, real party, and Joseph Calvin Morgan, real party and interest. Our cause number 1, SA150058. We have allocated, even though it's a special action, we've allocated 20 minutes per side. If counsel for petitioner wishes to have some time for rebuttal, let us know and we'll try to honor that, but it'll be up to you to watch the clock. I'm sure you're familiar with that process, and we'll try to honor that. And if both of you would state your name when you come to the podium, please, so that the recording will have that embedded in it for somebody who listens later. And having said that, Ms. Martin, you want to proceed? Now I've said your name, but I still want you to do it.
Thank you, Your Honors. Good afternoon. Lisa Marie Martin for the State of Arizona. And what we're here for today is to determine whether the Justice Court can give a proposed instruction which the state claims is a comment on the evidence and also an illegal application of collateral estoppel. Even though the trial court said it was denying collateral estoppel, in effect, it applied collateral estoppel. Before I get, I'm sorry, did someone?
Well, I was just starting to ask, is it your main concern that you don't agree with the content, or is it your main argument that no limiting instruction is needed?
Well, both, Your Honor. No limiting instruction is needed. We were pretty much told, give me a limiting instruction, and the state basically gave an instruction saying the BAC can be considered on the charges that are before you. I mean, if we were told to ask for an instruction, that's what we gave. But that's not the instruction that the court wanted to give. Before I get into the substance of the argument, I did want to clear up a misconception that the facts in my special action don't really cover adequately, but it is in the appendix. And that is a little bit about the facts of the case. And where you can find those actually are attached to the special action appendix 2, item 1, which is a memorandum regarding the remaining charges that the defense filed. And the attachment A to that was a transcript of a Rule 20 motion that the defense did at the close of the evidence on the first trial. And the two things are significant about that motion. The first is that the defense was arguing that they should get a directed verdict on the driving portion of the charges, because stating that the defendant was not driving. The defendant was found basically sound asleep in his truck, stopped at a red light, his foot on the brake light's on, his hands kind of not on the wheel, just sort of like here, and drool on his shirt, which the defense characterized as older drool, that looked like it had gathered there for a while, and was so unable to be woken that the police officer actually thought there might be some kind of a medical emergency.
Was the car in gear?
The car, yes, was in gear.
So the brake was the thing that was keeping him from rolling forward.
Right, so his foot luckily was still down on the brake and didn't come off. And so if you look at that Rule 20 motion, the defense argues that really wasn't driving, and then the defense argues, well, we should get Rule 20 on all of the charges, because even for actual physical control, this was not current or imminent control. The second reason that is...
He was using it as a shelter to sleep it off.
That's right, in the middle of the road in front of a light. not over to the side of the road, but...
So what's the second aspect of the...
Oh, I'm sorry. The second aspect that, like I said, I didn't make clear in my special argument, I hope it's special instruction facts, is in this directed verdict argument, is that this was a retrograde case. So that a retrograde means that to get it, well, I know you all know what it is, but basically the expert has to come in and get it back within 2 hours of driving or actual physical control by doing some sort of a calculation and absorption rates.
How many hours approximately, or specifically, if you know, was the blood test after the
It was actually a very short retrograde period that he had to do because the defendant refused all tests, but the defendant was arrested at 12:56 a.m. And was not given the blood test was not taken till 3:09. So it's about 14 minutes of a retrograde.
Okay, and the bearing on how that bears on the issues before us?
It doesn't seem to be an issue before us.
It is in the sense that when we talk about the issues of both the application of collateral estoppel, the end run around collateral estoppel through this jury instruction, and also what the state says is a comment on the evidence, there's the assumption that's made and the argument that's made by the defense that the only thing that you can draw from the jury's acquittal of the defendant on the extreme DUI is they rejected the .17 BAC for all purposes, that they found it inaccurate, not credible, and unreliable. And I think if you look at the fact that this is a retrograde case, even though that it has to only, even if it's 15 minutes, there are calculations and things that have to be presented to the jury. There are things about absorption rates that have to be presented to the jury. And
so they may have just not accepted the retrograde? Is that your
they may have been confused about the retrograde. They may have thought, well, maybe it doesn't get him all the way to a .15. I mean, they may have thought, and also another place in the record, which is
So you're saying that if they had recalculated the numbers themselves in the jury room, they may have missed a subtraction somewhere and ended up believing that they could get it to a .14, but not to a .15, much less a .17.
that I'm not being as exact as that, but that's basically my argument, that they may have just been confused and said, we don't agree that we can get to the .15. And there was also something that the defense said during the oral argument, which is in item 4 on page 8. The defense says in these cases that when the state testifies, they always talk about an error rate of plus or minus.
That's what I was going to get at. Is there some testimony about what the range of error was?
Unfortunately, Your Honor, and I take responsibility for this, I did not get in the record of the previous trial, except to the extent, I did not present it to you, except to the extent it was pieces of it were in the appendix, and the only part that was in the appendix was the part about the directed verdict, which talks about, both sides are talking about the facts, how the defendant was stopped.
Before the trial court, before the superior court, was any evidence presented as to that, was anything submitted on the special action, the superior court, indicating that there was evidence at the trial court in the justice court on range of error?
The thing that I am citing to you, and I actually did get this in the record, is that on item 4, which is the oral argument before the trial court.
Could you wait a second?
Oh,
this
sure.
is in your appendix?
Yes, it's our appendix 2, item 4.
Okay, one second.
Which is an oral argument dated 1/27/14, and this is before.
So appendix, is it, what, you know what appendix number it is?
The whole appendix is number 2 because I had and I thought this would be easier and hopefully it's not more confusing, but I had the same appendix when I took it to the Superior Court, and I ended up incorporating that 10-item appendix as all of Appendix 2 to this court. So first go to Appendix 2 and then go to item 4.
Reporter's transcript?
Yes, and then go to page 8, and it's just a statement by Mr. St. Louis, is basically saying the way these trials go, this state's expert said, here is a reading, plus or minus 5%.
And that's on page,
Page 8. And that may not be like the,
you could probably, you might be able to tell that I'm looking.
I'm sorry.
I'm looking on my iPad to find it, okay.
So the error, the expert said that the error rate was a plus or minus 5% of the reading?
that it could be plus or minus 5%. Let me see if I can find that exact.
Of 0.17.
Right. Now, would that take you down under 0.15? No. I mean, it wouldn't. But, I mean, maybe it's something that if you take that into account with also retrograde testimony that might have been confusing. What I'm basically using this for is the defense says that the state can articulate no scenario that the jury could have actually looked at that 0.17 and not just found it unreliable for all purposes when it acquitted.
Excuse me for interrupting.
Okay, I'm sorry.
But we've already used half your time.
Really?
Yeah, it's amazing, isn't it?
Flies when you're having fun.
me trying to find a factual reference for you.
Well, what I want to get factually an understanding of is this. Was the blood test result the 0.17, or was the retrograde the 0.17?
The blood test result was the 0.17, but that is how it was retrograded so that it got back the 19 or the 15 minutes, and that was the 0.17.
Did it go up? Well, wait a minute.
We don't.
After it was retrograded to within 2 hours of the arrest, it's 0.17?
Correct.
Okay, so it was something else before that? The
Correct.
actual blood test result was something else?
Correct.
What was
and
that?
I don't.
Okay, we'll ask Mr. St. Louis that. I'll bet he knows.
Okay. So basically the point of that is to show that we can articulate that a scenario in which the jury could have looked at heard retrograde evidence, could have heard the error rate, could have had some confusion and basically thought it's not as high as 0.15. But that doesn't mean that it was rejected for all purposes, and it certainly doesn't mean that the jury on the retrial for 0.08 and impaired to the slightest degree should be told by the judge that it has been determined as a fact that this is a purported result, and it has been proven not to reach 0.15. There's no reason why they should be told that. That is a comment on the evidence. And the defense says, well, we have to give some meaning to the jury verdict of the acquittal. Well, there is meaning. The defendant was acquitted of 0.15. He's not going to be tried of.
Why is that even of interest in the second trial? If you're looking at a second trial that is impaired to the slightest under an A1 charge or is a 0.08 under an A2 charge, don't you try those cases all the time? Don't you have A1, A2 cases that you try all the time?
Correct.
Why do you have to explain why you didn't charge an A3 or you didn't do a higher?
Well, I don't think you do, Your Honor. I don't think it's relevant, and it goes beyond not being relevant to tell them, oh, by the way, he was acquitted on this. I mean, that's just prejudicial because he's not being tried on that again.
Would it be relevant to tell them the truth, that he was charged with 0.15 or above and acquitted, not to characterize anything else, but just to tell them the truth? Maybe tell them he was charged with these two offenses that are now before you, and the jury was hung. Now we're starting over.
There really is no reason to tell them that. And also it is kind of an end run around collateral estoppel, because we really can't determine that the sole reason that they acquitted him was rejecting that blood result for all purposes.
It's not, I understand that.
Okay.
But I guess following up on Judge Campbell's question is, would it it's not the question, I don't think it's the question before us, but could the judge or tell them, just understand that he was charged with .15, or also charged with .15, and the jury acquitted? Could he, could that happen on remand? Let's assume that we granted relief. Let's assume we accepted jurisdiction, granted relief. The only thing we're being asked to say is this instruction that was given erroneous? On remand, could they could either the judge tell them or Mr. St. Louis try to get into evidence that he was acquitted of .15?
Your Honor, I have found no cases where they tell the jury that the defendant has been acquitted of one of the charges, which isn't before them. If you look at that, the U.S. Supreme Court case Dowling, where they actually talked about an acquittal, that was actually a 404B instruction, where it was a limiting instruction, kind of a 404B, saying we're introducing this evidence of the defendant robbing this woman or wearing a mask just for the purposes of identity. But they told him, but he was actually acquitted of that offense. But you always give that kind of limiting instruction on a 404B case.
But if you want to call it a limiting instruction, or as Judge Gilmore referred to it, sort of a just tell him the truth instruction, does that not invite speculation by the jury as to why a .15 would have been tossed, but a .08 still good?
Well, yeah, it does. I mean, honestly, it does seem counterintuitive in one way, because it's like, well, you tell them the jury acquitted him of it. You have a BAC of .17. The jury acquitted him of the extreme DUI of the .15. Now the .08 is before you. But if you think of it in another way, you know, just because they didn't find it was as high as the .15, the .08 is a lesser included BAC. And they could find, you know, say they had some doubts about the retrograde, or they had some doubts about the margin of error. It would be, you know, that very easily that they could go on to the .08. And to tell them that he was acquitted of the .15, that is just prejudicial and confusing, and it's not before them. That charge is not before them.
Does it also create potentially a defense argument that if he was acquitted of a .15, why would he not also be acquittable of a .08?
Well, I think actually that is something that you can ask yourself and say that shows that the verdicts were inconsistent. And that's something that the verdicts of the first trial were inconsistent, because if the jury in the first trial had truly rejected the .17 for all purposes, why would it have hung on the .08?
Aren't these all jury arguments? I mean, in essence, I don't think this exact question is before us, whether the judge tells them, okay, he was acquitted, the truth instruction, he was acquitted of the .15. And neither is it before us whether on examination Mr. St. Louis can ask questions about, well, wasn't he convicted of charged with .15 and the jury acquitted, to try to create reasonable doubt about the BAC. But those questions aren't before us, because that's something I would guess would be before the trial judge to figure out, is it admissible? Should I give an instruction? If I shouldn't give an instruction, is it admissible? Is it relevant? Is doing the 403 weighing, is it more prejudicial than not? Those are things that I guess would have to be argued down below, right? Assuming we said, don't give this instruction.
Yes, and 403 was argued to the extent when we objected to the instruction. It was argued saying the instruction also seems to imply that it only applies to the .08 and not to the impaired to the slightest degree. But also, what the judge does in this case, he says, you must accept this as a determined fact. I mean, that seems like it's the classic comment on the evidence, telling the jury in this trial how to treat the evidence. And all the cases that the defense cites that talk about, these are not comments on the evidence, is when it's uncontradicted or it's conceded or almost like a stipulation that you tell the jury. But to tell them at the beginning, this doesn't prove you have a purported result, which already sounds like it's fraudulent or imagined. You have a purported result of 0.17, and the instruction that we suggested is you may consider the alleged BAC result of 0.17 to the charges that are before you. That was basically what we suggested. To call it purported and to tell them in a proceeding. I mean, and even if the court at one hand said we're not going to let them talk about the previous trial, but at the other hand talked about a proceeding where it has already been found beyond a reasonable doubt that this doesn't prove 0.15, you must accept that as a determined fact. That's basically a directed verdict.
So you have to basically defend against a speculation or an assumption from a prior trial where you don't know that that's what they found or not.
Correct.
Thank you.
I have 26 seconds.
Use them well.
I'll try. Let me go. I think we talked about the defense says what else could have happened. I explained what else could have happened is we had inconsistent verdicts. Why didn't the jury acquit of the 0.08? Why did they disagree on the 0.08? They obviously did not reject the 0.17 for all purposes. I'm sorry, I've used up my time.
All right, thank you very much.
I didn't observe my 3-minute warning.
That's okay, happens
all right.
all the time, don't worry.
Thank you.
Thank you very much. Mr. St. Louis.
Thank you. Good afternoon. My name is Joe St. Louis. I represent the real party in interest, Joseph Morgan. I missed part of your argument because I was looking up for you, Your Honor, the actual...
Oh, I'm sorry to make you
No,
miss part
that's
of it.
okay.
So what was the actual blood reading before extrapolation?
It was a .170 exactly. That is in Appendix 7, and I can't tell you if it's Appendix 17 or 27 from the states, but it is the May 19th, 2014 transcript. It is on page 16. It is at lines 7 through 10.
So you're saying that, and this is entirely possible, that a 14-minute difference in the time calculated from did not result in a difference in the breath alcohol reading, or breath alcohol
Blood alcohol.
in the number.
I can't remember. They may have said it was slightly higher because of that, but substantially the same number.
17.1745 versus a .1763, right?
Yeah, and in this case, it was a 170, and I can't tell you what the fourth digit is. Maybe they said it was a 171 or a 172.
Counselor, what page was it?
That is on page 16. It's at lines 7 and 10. It is the May 19th, 2014 transcript. It is identified as Appendix 7. It is the state's appendix. I'm sorry, Your Honor?
Yeah, now.
But your point is that the blood test before any adjustment for time was .170. And is there another number then after it was adjusted for time? Maybe that's the same way of asking what Judge Jones was asking, but
I honestly can't tell you. My belief would have been they would have said it was slightly higher, but not a significant amount higher. If it was higher, it would have been higher to the third or fourth digit. And that's where we would have been. So really, Judge, what we're here, I think, to talk about today is what is the meaning of the first jury's verdict in this case? Because we have a jury, they had Mr. Morgan asleep in his truck. There was some dispute about whether it was on or off the road. He testified he had parked in a parking lot. The officer said no, he was on the roadway.
I take it both driving and actual physical control went to the jury?
Just actual physical control, Your Honor. Judge Reed decided that there was, I'm sorry, Reed Southern. So his last name is Southern, I apologize. Decided there was not enough evidence to let it go forward on a driving charge to the jury. He put it through to them on an actual physical control theory.
Mr. St. Louis, let me ask you a question.
Yeah.
If we just all agreed for a minute that what we had here was jury nullification, and they just decided that they weren't going to convict on an extreme DUI because of the past history of someone on the jury panel or something that happened to a family member, just accept that it was jury nullification and nothing more. Why, in going back to the trial court, would this not simply be a case of trying a 1381A1, 1381A2 case from the start?
Okay.
Why is this something special? And why, I suppose, does the state need to have to go in on the defensive in regard to a prior jury's actions that no one really has an answer to?
Well, I disagree that, I'm going to answer your question, Judge. I disagree that nobody has an answer to. The only logical conclusion you can reach based on the verdict, because everything else is the same. Guy's still asleep in the truck, blood is still drawn at the same time, same witnesses testifying. Jury looks at that, says, we're not convinced this blood test result is accurate enough to be a .15.
But it could be a .08?
Could be a .08.
Based on what distinction?
Based on, you've got to understand, we attacked this vigorously at trial. Mr. Flaxmeyer came in, talked about all the things that can go wrong in a blood test result from collection through testing. Mr. Schwartz talked about the methods that he used. We've got a jury that said, we don't buy that this is over 1.5, but it might be over .08. We can't make up our minds about that. Not good enough for us to say definitively, yeah, the guy was over 1.5, but we can't decide whether there's enough there for him to be over .08.
We know that's what the jury decided as opposed to jury nullification as an option, a belief in that the margin of error, with or without the retrograde extrapolation formula, etc., or that they had some question about whether he was sleeping it off or something like that. How do we know any of those things? How do we know anything more than that they acquitted on that charge?
Well, Your Honor, what we do is we presume that juries follow the law. And in this case, the law that was given to them was weigh the evidence. If they've proven it, convict the guy. If they haven't proven it, acquit the guy. And I don't think we can speculate that, well, maybe they did it out of sympathy. Maybe they just, had some bad experiences. I think Judge Jones was talking about. We have to presume that they followed the law.
No, but what I said was don't pay attention to those.
Yeah.
Let's just assume jury nullification. They just said, we don't like the 1.5. We're not going to go there. Why then isn't this a case of trying an impaired to the slightest .08 DUI like you guys do 150 times a year probably? Okay.
Two reasons. The first, as I've said, is we can't make that presumption. We can't just speculate that, hey, maybe it was jury nullification.
What presumption?
We can't. Well, you're right. The presumption is that they followed the law and didn't do jury nullification. You're right about that. So we can't speculate that they just did it on a whim or something other than following the law. But here's the second part of it, and I think this gets to the heart of your question, Your Honor. The state has had their opportunity to demonstrate the reliability of this blood test result. They came in, Mr. Morgan said, I'm not going to take a plea. I'm willing to be convicted of an extreme DUI if that's what the jury says. The state brought in their evidence. This jury said he is not guilty of having an alcohol concentration of 0.15 or more.
No.
They don't get to try to prove that it is an accurate, reliable 0.17 again because the first jury has rejected that.
Counsel, I'm going to let you know I disagree with you. I think that all that occurred was, and that is the jury found, the state did not prove beyond a reasonable doubt that he was driving with 0.15 or greater. That's all it did. It did not prove the extreme DUI. The reason they reached that decision, I have no idea. And they can't retry him on that. So we get back to the idea of, so this trial is simply impaired to the slightest degree, or 0.08. And that's all that's being tried. And if that's the case, why can't the BAC come in to try to prove 0.08?
The short answer, Your Honor, is because you're wrong.
Why am I wrong?
Well, you're wrong because what other basis could it have been? I know you guys want to speculate, well, maybe they just like the color of the guy's
Don't wanna
eyes.
We don't want to
Speculate.
speculate. That's okay.
We don't want to
wanna
speculate.
Okay.
Let me,
And may I finish that?
oh, sure.
Let me finish that. We don't want to speculate, and if you can give us a point in the record to look at that tells us that the jury found that the reading was in error, that the BAC was invalid, that'd be helpful.
Okay.
Excuse me, Judge.
And you have to look at the record as a whole, Your Honor. We have where he was found, we have where the blood was drawn, we have the witnesses who testified in the case. What the jury has said, we do not think the state evidence demonstrates he was a .15 or above while in actual physical control. We disagree about whether the evidence proves these other two things.
And part of this, if I'm following you correctly, Mr. St. Louis, part of this is your point on the presumption that they followed their instructions.
And that is, that's well-settled case law. We presume that the jurors, I'll grant you
In the absence of
there's-
reason to think otherwise is, in my view, implied and often left off when we write these things. But I think if we traced it back to its earliest days, originating from the Supreme Court of Arizona, it would be, we presume, in the absence of some reason in the record to think otherwise, that they followed their instructions.
That's right. And if you look at, and I'll grant you there is some tension between that concept, which seems sort of like black letter law, black letter law. I don't know if I said that correctly.
Black leather law might be different.
Yeah,
I
it
don't
would be a
know.
little different, I think. Whole different case.
Well, excuse me for interrupting, but I'm interested enough in this subject that I'm going to give both sides another minute or so, and I wanted to warn Ms. Martin that we might call on her to
Sure.
respond to your argument regarding our obligation or duty or the appropriateness of us presuming that on this record and in this case that the jury followed its instructions.
All right. Thank you.
And having said that, then let me let you get back to your argument.
Well, what I was going to say is there seems to be some tension because sometimes we have jury verdicts that don't make a lot of sense logically. You look at them and say, boy, it's hard to reconcile how they could have found not guilty on this one, guilty on the other one. And so we have this body of law that
We do have the
says,
case law that says we don't worry too much about inconsistent verdicts.
well, right, yeah, there is, we don't worry too much about inconsistent verdicts. But these verdicts aren't inconsistent. They didn't buy that the blood was over a 1.5. They couldn't decide if it showed that it was over a .08.
They were
and that's
not
all that we're dealing
necessarily
with.
inconsistent. I agree.
And so, what I had argued in the court below was, they rejected this blood, they've rejected it for all purposes, so you need to dismiss the charges. And the judge in the trial court did a pretty good job of splitting the baby. He said, you know what, I don't think this verdict means that they've said this alcohol concentration has to be below 0.08. In fact, I think it says the opposite of that. They haven't reached that decision. And so I'm not going to preclude it, but I will give the first jury's verdict meaning by telling them it doesn't show that it's over a 0.05. That goes back to the Steen case that I have cited to you, which was in the old days of the affirmative defense. And so there was a 1-1 reading, and the guy was acquitted of that. And then they wanted to retry him on the impaired charge, and he said, well, you've got to throw this out. You got to throw the blood out. And they said, well, no, you presented evidence that he was under a 0.08 at the time of driving. So that doesn't mean that the jury rejected that reading. So we're going to let the state use that reading. However, the state may not in any way suggest that this reading shows that the person has a BAC over 0.08 at the time of driving, because the first jury rejected that. And that's really all the judge did in this case. And it's just a a way of
But why-
leveling the field.
Why is it relevant in the retrial of the '08 and the impaired to the slightest degree, whether he was he was equal to or over .15? Why is that even relevant?
The reason that's relevant, I know Judge Jones had a question about that earlier.
Go ahead, please.
Okay. The reason that that's relevant, Your Honor, is that the way that the state proves up its charges is they bring in their analyst from the laboratory and they say, this is all we did and this is a very reliable result and we are confident that it is a .017 plus or minus 5%. And they've already had their chance to prove that to a jury. A jury rejected that evidence at the first trial and acquitted.
The jury at least found, for whatever reason, that it didn't convict on the .15. But the issue now is not .15.
The issue is not .15, but the issue is what does it mean in terms of what the state gets to say about the evidence in the case? Because we do have a jury that rejected the idea that the evidence that the state presented demonstrates that Mr. Morgan had a .15 within 2 hours of driving. And so that, how many chances do they get to try to convince a jury that it's an accurate reading of a .17?
So that really is what this is about, is trying to show that it is just an inaccurate reading.
That, in a sense, yes, Judge, that it doesn't show that it was a .15 or above.
Because,
however, I'm sorry, please.
I was going to say that what I keep seeing in my mind is like the start of a foot race. And usually we think you both start off equally, and you're going to race forward and try and convince the jury of your position. In this case, you're wanting to have the state take one step back or so because you want to start them off with the baggage of telling the jury that there's already been a negative ruling in regard to the BAC that they want you to rely on toward a .08 determination.
It's hard for me to think of an acquittal as being baggage, Judge, but to the extent that they're doing that, yeah, if they're going to retry the case, then they have to live with the decision of the previous jury and its consequences.
So effectively, it is a certain prejudice that they start off having to battle, the perception, without proof of it, really just the perception that the jury tossed out, for lack of a better phrase, the BAC reading.
See, and I guess we have, I appear to have a very fundamentally different worldview than you all do on this issue. To me, we've got the blood test. They tried to convince the jury of its reliability. The jury said, no, we don't buy that. You have not proven that it was a .15 or above. It may still be over the legal limit. We can't make up our minds about that. And that's frankly why this isn't a comment on the evidence, which is something the state complains about, because it's not telling them, hey, take this reading and make this determination about the .08. It doesn't tell them what to do. That's why it's not a comment on the evidence.
And you would argue also that it's not the judge's opinion, which is why it's not a comment on the evidence.
No, I would argue it's just a fact. And the fact is that this determination has been made by a previous jury.
Why is it not the case that if you got the court to agree to advise the jury that there had been a previous .15 charge that had been acquitted, that there had been an acquittal on, why is it then that you would not be offering that if they can't trust the reading for a .15, they can't trust the reading for a .08? Because there's no distinction. I mean, there is a blood test. And what we have is like a ruler that goes alongside that blood test, and it says, okay, you can charge an A1, you can charge an A2, you can charge the aggravators. So really, what you're looking for is, if you didn't like him at a .15, you're really not going to like him either at a .08 because it's the same test result, right?
I mean, ultimately, the second trial, we're going to be saying it's not a reliable test result.
Because of the acquittal on the .15.
No, I would say because of the same factors that led the jury to acquit on the .15, but not because that previous jury made that previous decision.
What is it about the first trial that is relevant in the second trial?
The verdict. The verdict that he was not guilty of having a BAC of .15 or above within 2 hours of being actually
whether he is or ever was guilty of a .15 or above is not an issue in the second trial.
Only in the sense, Your Honor, that the state will try to come in and convince a second jury this is an accurate and reliable .17 gold standard. I'm exaggerating now, and I think you know this flawless test.
But you and your client has the benefit of not being prosecuted anymore. He's getting a substantial benefit of not being prosecuted anymore for the extreme DUI. That's over. He's won.
I would agree that it's a benefit, but it's a hard-earned and hard-won benefit.
Sounds like it was. Congratulations.
Thank you. But he's still entitled, we still have to give that first jury's verdict meaning and weight. And what they've said.
What about the meaning that he's not being charged for it anymore? That's meaning.
Good in as far as it goes, but doesn't go far enough. Still the state doesn't get to come in and try to convince the second jury with the same evidence this is an accurate and reliable .17 when he's already been acquitted of that.
Because it's the same evidence?
Yes.
Or because of something?
Because it's the same evidence that has been rejected through a final determination, the jury's verdict. And Judge Kessler, you've had your hand up about 3 times.
Well, I want you to finish answering Judge.
I'm done.
Are you done?
Yeah, go ahead. When we get down to a minute, we'll add a minute more to both
Yeah, I was
sides.
going to say, yeah.
But not to Len.
It seems to me there's a difference between the judge instructing them about giving this instruction and the defendant trying to create reasonable doubt by asking, let's say in cross-examination, is it accurate that the defendant was charged with .15 and the jury acquitted him? And assuming the judge does the appropriate weighing and says, okay, I think this is relevant because it is trying to create reasonable doubt, because you're then going to, if it comes in, I would assume, would then argue to the jury at closing arguments, the prior jury has already acquitted him of .15 based on the same test. You can reach a conclusion that maybe that means that the .15 is inaccurate.
I think you're probably right, and you were probably saying this earlier, Your Honor.
We've added your 1 minute.
Got my minute. Thank you.
Go ahead. Thank you.
Oh, no, okay. That probably does achieve the same result, which is to notify this jury that has been rejected. Okay. And that is the purpose of the limiting instruction.
But if it's rejected at a .15, why aren't you in here arguing that it's also rejected at a .08?
I lost that argument in the trial court. I did make that argument in the trial court. I didn't special action that. I think you're right. That would be the correct decision. But the issue in front of this court today is, did the judge err as a matter of law, abuse his discretion by giving a limiting instruction on that issue? And he didn't. And Judge says, someone in the trenches, this happens all the time. You get a .215 blood result, and the jury convicts the person of being over a .08 and acquits on the higher ones because they make decisions about the reliability of the blood test evidence based on the evidence. That happens every day. They use one number.
Have this issue because it doesn't happen in a two-trial situation. It usually happens all in one, right?
I'm out of time, but you're absolutely right. When a jury has spoken, it certainly does make a difference.
We'll let you sum up if you have something more to say, particularly if you do.
Your Honor, really what we're concerned about here is giving weight to the first and meaning to the first jury's verdict in the case. The judge is not telling the second jury what to do with this evidence, how to decide the charges in the case. It's not a comment on the evidence. It levels the playing field. There was good foundation for the trial court to do this. It's not an abuse of discretion, so we would ask you to allow him to give the jury instruction at issue. Thank you.
Very good. Thank you, Mr. St. Louis. Ms. Martin, you have about a minute, and at least my question is, what about the point that seems to me to be a good point, that we should presume that the jury followed its instructions. And if we look at the case that way, then we probably shouldn't be speculating, it seems to me, about jury nullification or sympathy or something else.
Well, the speculation comes from this instruction and comes from the defense saying that this, on the second trial, we get a retrial on these 2 counts for the hung jury. And we shouldn't have to start off being told there was an acquittal on the .15, which basically that's what they're being told. There's being acquittal on the .15. And he's saying, well, otherwise, that's the only way that we can give meaning to the fact that he was acquitted. Well, what are they afraid of? That this new jury is going to say, hey, we know that .15 equals extreme DUI. Can you bring those charges here too? I mean, that's not before this jury. And they get to attack the same attack that they did on the blood evidence. This is a retrial. The judge, and it is a comment on the evidence when the judge is telling them that something has been proven as a fact. And I think one of you, I think it was you, Judge Gemmels, it just said, really, we don't really know what this acquittal was based on. We don't know that it was based on Mr. St. Louis's arguments that the blood test was unreliable, not credible, inaccurate. So he's saying, I shouldn't have to litigate that again. The state shouldn't be able to say that that is accurate. Well, yes, we should. We have a retrial, and we're doing it on 2 counts that we get a retrial on. And we don't know if the first jury decided it on the blood test because they didn't understand the retrograde, because they miscalculated the margin of error, because they thought an extreme DUI, that he would be punished more harshly, that they were trying to be lenient, that it was a compromised verdict. We don't know those things.
We've run through your minutes.
Oh, I'm sorry.
But
That was the fastest minute.
I think Judge Kessler has a question.
I may have asked this to you before, but I'm going to
Answer the same way.
I probably won't remember unless I review the tape.
Unless this answer's better.
Assuming that we agree with you, the defendant wants to create reasonable doubt as to the BAC. Could the defendant, counsel, in cross-examining your analyst or one of your witnesses, say, isn't it true that you state charged him with .17 and the jury acquitted?
Well,
and then, let me just finish it up. And then, with that, it's it. No instruction from judge. And then, in closing argument, say, if they acquitted then, it means you could conclude, you don't have to conclude, but you could conclude that they had some doubts about the BAC. And maybe those doubts should apply here too. Could they do that?
Well, it's my understanding, Your Honor, that there was, and maybe Mr. St. Louis can help me on this, that there was a motion in limine done by the state before the second trial that has never occurred yet, saying that the first trial could not be mentioned.
Sure.
And of course, in the instruction, didn't use the word trial, so that was sort of sanitizing that. But I would say that would be, could the defense try to ask that? I would say that would be objectionable, and that would be something that would, hopefully be covered by that pretrial motion in limine.
Although it's not technically the law of the case. I mean, the judge could reconsider it in light of the evidence and think, well, maybe I'm going to admit it.
Would it simply be error for the court to allow that to go unaddressed? Raising the issue of the prior trial and the subsequent hearing, subsequent trial.
I would argue that it would be erroneous, and that would be error, because they're supposed to decide on the evidence before this case, not what another jury did. The .15 charge is not before them.
Okay, we're going to take this matter under advisement. We'll issue a ruling in due course. Let's see, I think there's a stay from the Superior Court, right?
Yes, Judge Didsworth gave us.
Okay, and we will try to act with some dispatch, but without making promises. Mr. St. Louis and Ms. Martin, both of you have made good arguments. We realize the case is important to your clients, and we find it interesting, and we'll do the best we can. Thank you.